During the course of your lawsuit, you are asked a question during a deposition, a pretrial question and answer session, and it's a simple question. Have you ever brought a lawsuit before? What happens if you say no and in reality the answer is yes? You want to know the answer? Come join me for a walk in the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I'll tell you what happens. What you have just done is you have told a little white lie. You might have been thinking, hey, what's the big deal if I answer no and I brought a lawsuit before? Okay, isn't it important for me to answer questions about what happened in this case, about all the injuries that I suffered and all the details of this particular case? The answer is yes, that is important. And the opposing attorney will ask you many, many questions about the details of this particular case. But by way of background, the attorney has asked you a very, very simple question. Hey, Mr. Jones, have you ever brought a lawsuit before? And you think in the back of your mind, yes, you brought you brought two lawsuits, or maybe one. And you're thinking, he doesn't need to know that. Why should I answer yes? I'm just going to say no and see what happens. Is that a good idea? In my opinion, the answer is definitely not. Now you might be saying to yourself, I don't understand. What's the big deal? What happens if you say no and really the answer is yes? I'll tell you what happens. What happens is that what you have just done is you have told a little white lie. You have told something that is not true. You have testified under oath in response to a question, a very simple, straightforward question, something that is not true. Now, why does that matter? I'll tell you why it matters. Because these personal injury cases, these accident cases, these medical malpractice cases, they are all premised upon credibility, believability. Who is more believable, you or the people whom you have sued? Maybe it was a careless driver. Maybe it was a careless homeowner. Maybe it was a careless doctor who caused you harm and injury. And now, if your case goes all the way to trial, the jury will have to evaluate your credibility and the credibility of the various people whom you have sued. If you have told a lie, if you have said something that is not true, even if it's the smallest little lie, that is going to come back to haunt you. So, although you may have brought a lawsuit before, and it may not have been significant, it might have been, let's say, a small minor car accident case, or something else. Maybe you brought a small claims case, or who knows what. The fact is, if you have brought a prior lawsuit, you are obligated to tell the truth. You have to turn to the attorney and say, yes, I did. And he might ask you a few questions about it and then move on. But now, because you have gone ahead and say, no, I didn't bring another lawsuit before. I've never brought a lawsuit before. This is my very first lawsuit. You should know that as part of the background that the defense attorneys do, they look to see whether you brought any other lawsuits before. And if you now say something that is not true, he's going to know it immediately. And you know what? In all likelihood, he's not going to confront you during the course of your pretrial questioning, known as a deposition, an examination before trial, which typically in pre-COVID times would take place in your attorney's office. And the opposing lawyer would be there, your attorney would be there, and you would be there. Nowadays, it takes place on a Zoom video call. But you should know, the answers that you give in response to these questions carry the same exact weight as if you are testifying at the time of trial, in court, in front of a judge, and in front of a jury. So now, if you lie about one little thing, here's how it's going to come back to haunt you. At the very end of your trial, the defense attorney is going to ask the judge to give the jury a legal instruction. And it's a very simple, straightforward instruction that basically says, if you find, ladies and gentlemen of the jury, that this witness has testified falsely about one little thing, you are entitled to disregard some or all of their testimony. Can you imagine that? It's called falsus in uno. That's a fancy Latin phrase that basically says, if you testify falsely about one thing, how can we believe anything else you've told us about? How can we believe that the things that really do matter are really true? Why? Because you have already told us something that isn't true. You have lied about something that was insignificant and should have had no bearing on this case. But you, the injured patient, the injured person, the injured victim, have chosen to make this an issue. Why? Because you have said something that is not true. So although you may think that it's no big deal to tell the defense lawyer that you don't have any other prior lawsuits, you now raise a big problem for yourself. you raised a credibility problem, and that is likely going to come back to haunt you and your case. So why do I share this great information with you? I share it with you just to open your eyes, to help you understand exactly what occurs in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You and I recognize that you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.